Thank you, Madam Acting Deputy President. I rise to speak on the Commonwealth Electoral Amendment ensuring fair representation of the Northern Territory Bill 2020. But before I do, I would like to acknowledge the great festival of democracy that was held on the weekend in the Northern Territory, and in particular thank and congratulate all the candidates who stood for election, but in particular acknowledge the work of Leah Whanokaiara, the leader of the Country Liberals. I did work for the Country Liberals back in 2012 as their campaign director, when we were very fortunate to come to power after being in the wilderness for a number of years. And Leah is one of those brilliant politicians who has what I call the X factor. But congratulations to her and Sally Ann Innes and everybody involved with that campaign. I'll have more about that to say at a later time. This bill, introduced by Senators Farrell and McCarthy on 11 June of this year, would amend the Commonwealth Electoral Act to provide for a minimum of 2 divisions for the Northern Territory in the House of Representatives. The introduction of this bill was predicated on research that projected the possibility that the Northern Territory would lose one of its 2 seats in the House of Representatives, caused by its population falling below the entitlement quota for the 2nd seat. So on the 12th of June of this year, Minister Cormann, as Special Minister of State, wrote to the Joint Standing Committee on Electoral Matters to ask it to inquire and report back on this bill early in the spring sittings to ensure timely deliberation before redistribution processes for the Northern Territory could become too far advanced, and for senators to hear from appropriate experts and from members of the community, but also including government agencies, on the administrative and legal implications of this bill. So, as Chair of the Joint Standing Committee on Electoral Matters, I want to briefly update the Senate on this inquiry and on some of the evidence that has been received. So on the 17th of June, after receiving Minister Cormann's request, the committee resolved to adopt an inquiry into the bill, which was subsequently publicised via media releases and in the form of invitations to interested parties. It was only during the inquiry, and this was on the 3rd of July, that the Australian Electoral Commissioner formally made the determination to increase the number of seats in Victoria from 38 to 39, to decrease the number of seats in Western Australia from 16 to 15, and to decrease the number of seats in the Northern Territory from 2 to 1. And this was based on the most recent official population figures for the Commonwealth published by the Australian statistician. So what I will do is go into a bit of detail in terms of how this has come about. So in terms of the population quota for one member is about 172,537 people, to be precise, with partial quotas over 0.5 rounded up. Unlike the states, the territories are afforded an additional calculation process to account for the margin of error related to their population at the last census. This margin of error calculation was introduced by the Howard government through the Commonwealth Electoral Amendment Representation in the House of Representatives Act 2004, following the recommendation of JSCAM's 2003 Territory Representation Inquiry. The NT population shortfall for a second member was 11,526. This was more than its population margin error of 7,440. As such, it did not retain its second seat. The ACT population shortfall for a third member was 1,784. This was less than its population margin of error of 10,694. As such, it retained its third seat. The 31 December 2019 estimated resident population data was published by the APS in June of this year. These were the most recent statistics required to be used by the Electoral Commissioner under the Electoral Act for the calculation of the entitlements ahead of the next election. The determination of reduced entitlement for the Northern Territory to one member only applies immediately for the purposes of enrolment. The members elected at the 2019 federal election, representing the division of Lingiari and the division of Solomon, will continue to represent those electorates up until the next election. Part 3 of the Electoral Act specifies the process to be followed to determine the number of members of each state and territory, when it is to be conducted and by whom it is to be conducted. The number of members in the House of Representatives for a state or a territory is based on the population of that state or territory relative to the population of all other states and territories. Some margin of error adjustments are made to the territories to account for the accuracy of their census population data. So enrolment is not relevant to the entitlement to members in the House of Representatives. The allocation of members by jurisdiction involves a calculation that divides the population of the state or territory by a population quota. Partial quotas, as I indicated earlier, over 0.5 from this calculation are rounded up. So, in essence, the population quota equals the number of people of the Commonwealth as ascertained by the Electoral Commissioner, divided by twice the number of senators twice the number of senators for the states. In calculating this quota, the number of people of the Commonwealth does not include the people of the territories. The Electoral Act requires the Australian statistician to supply the Electoral Commissioner with the populations of the states and territories which have been compiled and published in a regular series under the Census and Statistics Act of 1905. The information to be supplied by the statistician is required to be published immediately prior to the day for the calculation, that is, one day after the House of Representatives has been sitting for 12 months following an election. The ABS also publishes the estimated resident population for each quarter. Now, adjustments may be made to the ACT and NT population as follows. The ACT to include the Jervis Bay Territory and to include Norfolk Island, where the latter is not entitled to a member in its own right, and the Northern Territory to include the Christmas Island Territory and or the Cocos Islands Territory, when either or both of these territories are not entitled to a member in their own right. In both of these cases, the population of the smaller territory is added to the population of the ACT or the Northern Territory, and the number of members to which the ACT or the Northern Territory is entitled is recalculated. This is an additional calculation which is made where the entitlement for the ACT or the Northern Territory is a whole number and a remainder that is less than or equal to 1/2 of the population quota. Depending on the outcome of this calculation, a further adjustment may be made to the population and the number of members recalculated. And this is the margin of error calculation that was introduced in 2004. Now, Section 24 of the Constitution does specify that 5 members at least shall be chosen in each original state. And as has been pointed out by speakers, Tasmania is guaranteed a minimum of 5 members of the House of Representatives as an original state of the Commonwealth of Australia. And Section 122 of the Constitution allows the Parliament to make laws for the territories and provides that the Parliament may allow the representation of such territory in either House of the Parliament to the extent or the terms which it thinks fit. Subsection 48(2)(b) of the Electoral Act requires at least 1 member of the House of Representatives should be chosen in the ACT and the Northern Territory at a general election. This provision was introduced through the Electoral and Referendum Amendment Act of 1989. Prior to the 1989 Act, the Commonwealth Electoral Legislation Amendment Act 1983 fixed 2 members for the ACT and 1 member for the Northern Territory. I think it's also important, Madam Acting Deputy President, that we sort of also look at the historical representation in the Northern Territory. And the NT, or the Northern Territory, was first represented by 1 member in the House of Representatives in 1922 through the Northern Territory Representation Act of 1922. But it should be noted that the voting and participatory rights of the NT member were initially restricted. They could not vote on any question, be counted in any situation where numbers mattered, for example, quorum or an absolute majority, and they could not hold office as a Speaker of the House of Representatives or a chair of a House of Representatives committee. In 1936, the Northern Territory member was granted the right to vote on any motion to disallow any Northern Territory ordinance and on any amendment to such motion. In 1959, the Northern Territory member's right to vote was extended to include any proposed law relating solely to the Northern Territory. In 1968, the Northern Territory member was afforded the same rights, privileges and immunities as members for other states. The Northern Territory Representation Act was repealed and replaced by the Commonwealth Electoral Legislation Amendment Act of 1983, which transferred Northern Territory representation provisions in the Electoral Act and retained the Northern Territory's fixed entitlement to one member. So I think it's very important to be aware of the historical background of representation in the Northern Territory, but also, Madam Acting Deputy President, to be fully aware of the legal background upon which redistributions take place in Australia and the basis upon which redistributions do take place. And so since the inquiry into this bill was established some months ago, the Joint Standing Committee on Electoral Matters has received written and verbal evidence from over 50 individuals and organisations. And while it was the committee's original hope to travel to the Northern Territory to hold in-person hearings, the committee secretariat received advice that this was probably not appropriate considering the coronavirus pandemic that is currently sweeping Australia. So the committee instead agreed to hold the hearing via teleconference on the 21st of July. And at the hearing, the committee heard from the Australian Bureau of Statistics, and as Senator McCarthy indicated, we heard from Senator McCarthy, along with the federal members for Solomon and Lingiari. We heard from the Australian Electoral Commission. We heard from officers from the Department of Finance, election analyst Malcolm McGrath, AO. For those who might be listening along at home, that's Professor McGrath who came up with the McGrath pendulum. The ABC's Anthony Green, as well as a number of representatives from either the Chamber of Commerce or the Isolated Children's Parents Association, Indigenous organisations and other individuals. Some were supportive of the bill, others called for amendments or changes to the formula. In saying so, responses to questions on notice arising from the hearing were due last week, and there are some submissions that the committee still needs to consider before publication. And it is my understanding that the committee secretariat is now working through the evidence that we have received. And the committee had agreed to consider the report in early October. However, it is my preference, and I'm looking across at my Labor colleagues over there, that subject to the view of other committee members and without wishing to step on their toes, and considering the workload of the Secretariat, that I would hope that we can report back sooner than that, given the formal determination by the Australian Electoral Commission in July. In closing, we do need to consider the evidence soberly and with due consideration, Senator Farrell. And in closing, has been an important and long-standing convention that electoral legislation should generally be changed based on bipartisan consensus and after appropriate opportunity for scrutiny of legislation. And I do hope that the Senate considers the committee's forthcoming report and recommendations prior to any vote on this bill. Thank you.